Wow, there's been a lot going on in the last couple of days. After months and months and months of waiting to hear something, suddenly we hear a lot of things. And, for all the information that we got, I suspect many of you agree with me that there's an awful lot that we still don't know. I'm not going to try to cover all of the known unknowns or the unknown unknowns. But what I am going to talk about is the relationship, such as it can be divined, between the new Department of Justice Civil Cyber Fraud Initiative and CMMC 2.0. There is a relationship, but it's lacking in certain details and coherence. To get to the bottom line up front, there's certainly going to be more pressure from the Department of Justice should it be informed of cyber activities that appear fraudulent and egregious. And they're going to be encouraging whistleblowers to come forward. Frankly, one of the reasons that they encourage whistleblowers is that DOJ has relatively little actual experience in bringing cyber fraud cases, and they seem to know, in all honesty, relatively little about it. And so one of the key roles of the whistleblower is not only to provide the insider's perspective on a problem that might not otherwise be known, but also to provide technical expertise so that DOJ or an assistant U.S. attorney or the inspector general can understand what this is all about. Many of you have heard me speak sometimes more as a security person and maybe sometimes more as a lawyer. Here I'm going to be talking a little bit more as a lawyer, and some of the work I've done actually has been to defend companies that are accused by either the Justice Department or whistleblowers in False Claims Act actions. So I'm talking a little bit from experience, and yet, experience has its limits, especially as we get into new areas. So I'm going to start out by mentioning the statements of the Deputy Attorney General, Lisa Monaco. These were made around October 6th. And it's interesting that as I've gone through a number of separate statements of DOJ officials, including some remarks that were made just yesterday by senior DOJ officials at a webcast. What I find is that, they all insist that the department wants to enforce cybersecurity measures, but they're not particularly, consistent. And reading between the lines, they know more what they want to achieve than kind of how to achieve it. This should not mislead anyone into thinking that it's okay to do bad acts or that you'll get away with it. Not so, but it does indicate that it's going to take a while for DOJ to sort of figure out what to do and how to do it successfully. So Ms. Monaco said at the upfront, she said, this initiative is going to hold accountable entities or individuals that put U.S. information or systems at risk. Well, first, I want to point out that they're looking not just to entities, companies, but to individuals. And, if you consider what's been said about CMMC 2.0 and these new requirements of affirmations by senior officials for the new level 1 or for a level 2 if you don't have defense critical information. Whenever you have a senior official who's called upon to make an affirmation of representation, there is some element of risk to that official, that falsity of that affirmation or representation or the underlying information could expose them to a false claim risk. And that's, part of their objective is to hold individuals accountable and motivate individuals to cause their entities, companies to work. She also says that the initiative focuses on knowingly providing deficient cybersecurity and products or services. Well, that sort of, what does that really mean? Well, its real application is probably to those companies who actually are under contract to the government to provide them cybersecurity products and services. If you are an entity that is operating a system on behalf of the government or providing it cybersecurity products and services, then you're going to be held accountable to the False Claims Act for knowing misrepresentations of your product or perhaps knowing failures to report deficiencies once known. But many of the companies that are affected by CMMC, most, are not in the business of providing cybersecurity products or services to the government. They are in the business of providing supplies or services to the Department of Defense. And they do have that 70-12 clause, which requires them to deliver adequate security in a dynamic environment. So, there's a little bit of a misfit between this initial emphasis Ms. Monaco cited and what most of you are worried about. But she goes on to say that another key purpose is to hold accountable entities or individuals who are knowingly misrepresent their cybersecurity practices or protocols. Well, this gets us a little bit closer to the present regulatory regime. And specifically, there's sort of two elements to it today, and then we can talk a little bit about the future. Today everybody has the 70-12 clause, which is this sort of an implicit attestation that by taking a contract with the 70-12 clause, you're going to act in accordance with NIST Special Publication 800-171. But beyond 70-12, we now have 70, 19, and 20. Those are the ones that require conduct of a self-assessment using the DoD assessment methodology. And those require that you report to DoD, to SIPRs, your score as the result of your self-assessment and the date by which you plan to close any gaps. Well, those are forms of representation. And it is possible that the DOJ or whistleblower could look at a knowing misstatement of a SIPR score, reckless disregard for when you actually intend to or are able to close those gaps and find a basis to at least blow a whistle and see whether a case could be made. I want to stress on the sort of legal side that, there's a considerable difference between an allegation of misconduct and, causing that allegation to reach the point that a case is filed under the Civil False Claims Act. And there's a considerable difference between such a case being brought by a whistleblower or relator, as they are called technically, and such a case being adopted by the Department of Justice. And apart from whistleblowers, there is always the possibility that an assistant U.S. attorney or Main Justice itself will decide to bring such a case. And I expect that they will, but they're going to be looking truly for egregious situations where they can make examples of companies. And they're probably going to find some. They may not succeed in as many cases as they might suspect because they're in an area that's considerably murky. But the mere fact that they are intending to act with the False Claims Act ought to give us all, ought to inform all of us to be careful. If you are doing the right thing, if you are recognizing problems when they occur and acting appropriately to report and to fix them, no problem. But if you get into decisions where you conclude it is better not to disclose, than it is to disclose or to lie about your cyber progress than to tell the truth, you're entering into that boundary area. And as I've emphasized many times, if you find yourself in a situation where a False Claims Act allegation has been made, you will experience a substantial expense and disruption and considerable risk for an extended period of time, even if the allegations are not meritorious. And so I think many people in the governance risk and compliance are going to be thinking that it's better now to do a little more in cyber rather than less and report a little more fully rather than not at all. And yet, there are some tensions.
So, Bob, I got a quick question. This actually came from somebody on the webinar. With level 1 now being self-assessments and portions of the level 2, and the potential risks with FCA, like you're speaking of, do prime contractors have a responsibility, and what do you think they're going to do for ensuring that those self-assessments are accurate when they are submitting teams or submitting for contract awards?
Well, that's a great question. So, level 1 now and in the future is a situation where self-assessments will be required, and they will also be relied upon for level 2. But there is a distinction, between today and what will happen when the new regulations are in place. There is something, of a gap in requirements. What applies today is 70-12, 70-19, and 70-20. And so those are the things that are going to govern what your obligations are in terms of cyber measures as well as what duties you have to report. Only when the new regulations are in place will we see these new attestations required by senior officials. So let me jump, sort of get to your question. So as to the primes, DoD has always recognized that it has privity of contract with primes, and that it has the highest leverage against primes. And DoD really doesn't have the instrumentalities or the people to go through the supply chain into the depth of a supply chain to be sure that security is accomplished. So they do have that leverage in the contract, and they continually use it to try to get primes to be accountable, or at least partially responsible for the security of their subs. That said, I mean, I don't think it's becomes necessary or plausible for primes to be absolutely certain that any participant in their supply chain at any tier is fulfilling its obligations. Yes, they will flow down. And yes, there are measures of diligence that they can take. And yes, I think more primes will be more insistent upon security and demonstration of security than perhaps in the past. But it wouldn't be right to tag primes for misconduct at a lower tier where they had no practical means of knowing of the misconduct. If they are lied to by a third tier supplier reporting up the chain, they can only act upon what they're told. They can ask good questions, they can ask for demonstrations, but there is some ability on the part of the lower tier to decline to answer questions, and there's some possibility that they might be misleading in the responses they give.
So Bob, with the False Claims Act, many people are asking questions, here on the webinar, and I've heard other people outside of the webinar asking questions about False Claims Act because they're just not that familiar with it. What is the likely outcome of an FCA finding? What kind of penalties are you talking about in those kinds of situations? What have you seen in the past?
Well, one of the big questions in this area is what are the damages? Now, in the worst case, the government can collect penalties, and they can, for each false claim, they can range between $11,000 and about $22,000. And they also can get treble damages. Now, treble damages could be enormous if they were able to put some figure of damages. But in a situation, say, where the false claim is that you didn't make a timely disclosure of a breach, well, what are the government's damages? I can generate scenarios where the government might lose all the value of a particular product that a company developed. Well, in that horrific situation, the treble damages would be 3 times the amount paid by the government for that product that was rendered worthless or unusable by reason of a cyber breach. But that's an unlikely contingency. In many situations where there could be allegations of misconduct, say arguments over particular controls or disagreements over when poems will be closed or misrepresentation of a SIPR status. In all those situations, the government may be harmed in that it's getting less than it expected, but it's difficult to monetize, the damages that the government actually occurs. And so I think damages are going to be hard to get in these cases. However, I don't want to undervalue the significance to you as a defense contractor of the penalties. And if you are a large company and you are submitting invoices to the government daily, it might be that there could be dozens or hundreds of invoices that are submitted under a contract or during a period where you were engaged in the misconduct that was the subject of the allegation. And if you took 100 examples and you multiplied that times $22,300 as the maximum penalty, that's a big number. And further, the process of an FCA action is one where the government often takes a highly intrusive posture. You could hear from the Inspector General, you could hear from DCIS, you could get subpoenas. There could, in really severe cases, there could be a related or combined criminal investigation. And even if it's a civil case, and even if it is instigated by a whistleblower, just the interest on the part of the IG in exploring more as to whether a case is there is going to require you to hire people like me and associates, and hire experts and consultants and the like to know what you did and to defend it. So I just have to emphasize that even if it's going to be difficult for DOJ to win the big case, of a cyber misconduct. And even if they're going to have trouble finding a case with actual damages that could be troubled, this is an experience none of the companies listening on this call want to have.
Well, thank you very much, Bob. I appreciate that. Really good information. Thank you for the rundown. I think that's a take that I think most people haven't heard thus far. So hearing that about, from DOJ is really good information. So why don't we move on, and we may come back for some additional questions if you can hang around, Bob.